Hello everyone, and welcome back to Law Logical, your weekly dose of legal knowledge simplified. If you're interested in learning about Indian law, or just want to understand more about the civil litigation process, you're in the right place. So, be sure to subscribe and hit that notification bell to stay updated. In our last video, we gave you an overview of the 18 stages of a civil suit under the Civil Procedure Code, 1908. Now, we're diving deeper. Over the coming weeks, we'll break down each of these stages one by one. Today, we start with the very first and fundamental step, the presentation of plaint. Let's get started. Every civil suit begins with a critical foundation, the plaint. Simply put, the plaint is the formal written complaint filed by the person initiating the case, known as the plaintiff. This document sets the entire case into motion, outlining the grievances, the relief sought, and the specific grounds on which the claim is based. Why is this stage so important? Well, it's essentially the framework of the lawsuit. Think of it as the blueprint for the case, where every fact, demand, and claim is laid out in a structured format. So, how does one file a plaint? Let's walk through the steps involved. The very first step is drafting. The plaintiff, with the help of a qualified advocate, drafts a comprehensive document stating all essential facts. Here's what a good plaint must include. Basic details. Names and addresses of both the plaintiff and the defendant. Statement of facts. A clear narration of the incidents or agreements that led to the dispute. Cause of action. This part is crucial because it establishes why the plaintiff believes they have a valid legal claim. Jurisdiction. It's important to mention why a particular court has the authority to hear the case. Relief sought. This is where the plaintiff specifies what remedy they're seeking, like compensation, injunction, or any other specific relief. A well-drafted plaint is precise and relevant. Every word in it should serve the purpose of strengthening the case. Step 2. Paying court fees and submitting the plaint. After the plaint is drafted, the next step is submitting it to the appropriate court, along with the required court fees. The amount of these fees depends on the nature and value of the suit. This ensures the plaintiff's commitment to the case and contributes to the costs of court proceedings. Step 3. Verification of plaint. Once submitted, the plaint has to be verified. This means the plaintiff or an authorized person must affirm that all the details provided in the plaint are true and accurate to their knowledge. This is a significant step, as any false information can have serious legal consequences later on. Now, you might wonder, do I really need an advocate to file a plaint? Well, technically, you can file a plaint yourself, but an advocate brings invaluable expertise to the table. An experienced advocate can draft the plaint effectively, ensuring no critical detail is missed. They choose the right words to strengthen the case, advise on the jurisdiction and the exact amount of court fees, and help anticipate any procedural challenges that could come up in later stages. Engaging a good advocate means you're giving your case the best possible start. The presentation of the plaint is not just about the paperwork, it's about laying down a strong, legally sound foundation for the entire lawsuit. Let me give you a couple of quick examples to illustrate why a well-drafted plaint and a good advocate are so crucial. Imagine a business owner filing a plaint against a supplier for breach of contract. If the plaint is vague and doesn't detail the terms of the contract or specify the damages caused by the breach, the court may struggle to understand the exact nature of the claim. In such a scenario, the plaintiff might not get the relief they're seeking. Consider a tenant filing a case against a landlord for eviction without notice. If the plaint fails to include the terms of the lease agreement or doesn't state why the eviction was unfair, the tenant's case could become weak. A skilled advocate would ensure that every relevant detail is included, creating a strong base for further proceedings. So, as you can see, The presentation of the plaint is much more than just filing a document. It's about effectively setting the stage for the entire case. A well-drafted plaint can streamline the proceedings and strengthen the plaintiff's position from the very beginning, while a poorly drafted plaint can lead to delays and even harm the case's outcome. That's it for today's deep dive into the presentation of plaint, the first stage of a civil suit. We hope you found this video helpful. If you're new here, don't forget to subscribe to Law Logical to stay updated on each stage of a civil suit as we dive deeper week by week. Let us know in the comments below if you have questions or topics you'd like us to cover. Thank you for watching, and we'll see you in the next video as we move forward to the next stage in the civil suit process.